We now move on to inchoate offences under Malaysian law, and we will see that we will be focusing mainly on the offence of attempt, because the other inchoate offences has already been dealt with when we talk about participation. Now, when we talk about inchoate offences under English law, we looked at the three forms of inchoate offences: encouraging or assisting a crime, conspiracy, or attempt. Now, with regards to the Malaysian version of encouraging or assisting in a crime, we can see in section 107, it is actually covered in 107A. When you talk about a person abetting, the doing of a thing is when he instigates any person to do that thing. So this will also cover things like encouraging a person to do that thing. Okay, and in assisting another person to do to commit a crime, you can see that this is covered under 107C. So we have talked about it already, right? In instigating and intentionally aiding, because we saw that for instigating and aiding, this is covered under 108, which is when a person is an abettor, and according to explanation 2, a person who is an abettor is basically a person who commits an inchoate offense, right? You see, explanation 2, to constitute the offense of abetment, it is not necessary that the act abetted should be committed. So all those four methods of being an abettor, which is instigating, commanding, conspiracy, and aiding, these are all inchoate offenses. So we have covered it already. So similarly, for the offense of conspiracy, this is also covered under 107B, engages with one another person in any conspiracy for doing of that thing. This is also covered under 120A, criminal conspiracy. So we have talked about conspiracy already under Malaysian law. And so we'll just be focusing on the offense of attempt. And attempt under the penal code is provided for under section 511, right? Under section 511. You look at section 511, whoever attempts to commit an offense punishable by this code or by any other written law with imprisonment or fine or with combination of such punishments, okay, or attempts to cause an offense to be committed, and in such attempt does any act towards the commission of an offense, shall, where no express provision is made by this code or by such other written law, as may the case may be, for the punishment of such attempt shall be punished with such a punishment as is provided for the offense. So if you are caught for attempting, by charged for attempting theft, you'll be punished as if you have committed theft, right? This is only for situations where there is no express provision is made. So there are some express provisions which are made. For example, section 307 talks about attempt to murder. So although the punishment for murder is death, attempted murder is not death. So we can see it in section 307, 308 talks about attempt to commit culpable homicide, 309 attempt to commit suicide, 393 attempt to commit robbery, 121 is waging war against the Agong, and 385, 387 putting a person in fear of injury, death, or grievous hurt in order to commit extortion. So these are specific provisions which deals with the offense of attempt. So 511 deals with the situation where there are no specific provisions to deal with attempting to commit a particular crime. And we see that the actus reus for attempt is basically doing any act towards the commission of such an offense, right? Doing any act or does any act towards the commission of such offense. Now, local cases have basically defined this or interpreted this as very similar to English law, right? Doing an act towards the commission of such an offense is doing an act which is more than merely preparatory. So therefore, to determine attempts under Malaysian law, basically is similar as under English law. We got to see whether the act is more than a merely preparatory act. We look at the illustrations found under 511. There's one illustration where he puts his hand into a jewelry box and finds that there was no jewelry inside. So he failed to commit the offense of theft, but he can be charged for attempted theft. Similarly, also a person puts his hand into the pocket of the victim and finds that there was nothing in the pocket. So no crime committed, that he didn't manage to steal anything, but he can be committed. He can be charged for attempting to commit the offense. We also look at the cases, right? In the case of Abayanan Mishra, this was a case where the accused faked a certificate in order to sit for an examination, right? So he faked the certificate, he applied to sit for the examination with a fake certificate, he even paid for the examination, but he didn't turn up to sit for the examination. So he wasn't charged for cheating, but he was charged for attempted cheating. He attempted to cheat. And it was held that he was guilty of attempt because the court said that you have to show that the accused carried out what was intended, but for some reasons, the criminal act could not be completed. So he carried out everything. He made the application, he paid for the exam, but for some reason, he could not complete it. He could not sit for the exam, because if he sat for the exam, then the cheating would have been committed already. Now, another case, this is a local case, the case of Ki Aba. This was a case where the accused wanted to smuggle tin ore, right? He wanted to smuggle tin ore through the causeway into Singapore, right? He wanted to do that to avoid being taxed for the tin. So he hid it into his car. He drove to the immigration checkpoint. He filled in all the forms, and he was heading towards the customs when he suddenly turned back and went back to JB. Now, he was said to have actually done acts which are more than merely preparatory, because he actually filled in the forms, submitted the forms already with the immigration, but he just turned away when the customs was about to check his car. So this is basically attempts under the Malaysian law. Now, we are also going to look at the attempted murder under 307, because even though we are not covering murder, we have covered murder already. But Section 307 gives us some illustrations which may help us to understand attempt better. Okay, so we are looking at the illustrations to help us to understand attempts better. The first illustration under 307 is A shoots Z. Right? A shoots Z with the intention to kill Z. Under such circumstances, if death ensued, then he'll be guilty of murder. But if for some reason he shoots at Z with the intention to kill him, but Z doesn't die, then A will be liable for an attempted murder and will be punished under Section 307. So here, he clearly has done acts which are more than preparatory. Okay, he has shot at the victim, but for some reason, the victim did not die, even though the intention was to kill the victim. Now, here's another example, right? A, with the intention of causing death of a child, exposes it in a desert place. So he has already committed an offense defined by this section, which is attempted murder, because he left the child in a desert place with the intention to cause the death. So even if the child doesn't die, right, he will still be liable for attempted murder. And illustration 3, A, intending to murder Z, buys a gun and loads it. Now, this is just merely preparatory, right? Taking a gun and loading it is just acts which are merely preparatory. So A has not yet committed the offense of attempted murder. But if he fires a gun at Z and Z doesn't die, then it would be attempted murder. Okay, so similar to illustration 1, if he fires the gun at the victim and the victim doesn't die. Of course, if he fires the gun with the intention to kill the victim and the victim dies, then it would be murder. But if he fires at Z with the intention to murder Z, but Z doesn't die, then it would be attempted murder. And finally, A, intending to poison Z to murder him, purchases poison and mixes the same in the food, which remains in A's keeping. So the food is still with the poison food is still with A, So therefore, A has not yet committed attempted murder. But if he places the food on Zach's table or delivers it to Zach's servants to place it on the table, then he would be liable for attempted murder. Now, in the case of Om Prakash, this was a case where he tried to murder the victim by starving the victim, right? By starving the victim. And it was held that the person commits an offense under 307, which is attempted murder, when he has the intention to commit murder, and in pursuance of the intention, he does an act towards its commission, irrespective of the fact whether the act is the penultimate act or not. I think that the key thing regarding this Om Prakash case, as we can see in what was held here, is that it doesn't have to be the penultimate act, as long as he has done certain acts, right, in order to commit the offense. As long as he done certain acts in order to commit the offense, that would be sufficient. Now, moving on, let's talk about what about impossible attempts, in the sense that what if it was the crime that was attempted was not possible to be committed? We looked at this under English law, and we seen that under English law, it doesn't matter that even if it was impossible to commit the crime, the person can still be guilty of attempting to commit the crime. And this seems to be the case also under the Penal Code, as we'll see in the illustrations. The first illustration was when he wanted to steal jewelry and there was no jewelry. So it was impossible to steal jewelry that was not there in the first place. Or a person puts his hand into the pocket of the victim and there was nothing in the pocket. So it was impossible for him to take anything from the pocket, right? But it can still be said to have attempted to commit the offense. So therefore, the situation is quite similar to English law. And we can see also in the case of Munah binti Ali. This was a case where the accused was charged for an offense under 312, read with 511. The offense under 312 is the offense of causing miscarriage, right? Causing miscarriage. So 312 read with 511 is an attempt to cause miscarriage, because in this case, the victim thought that she was pregnant. So the defendant here tried to cause abort the child, right? But found out that the victim did not have a child at all. So therefore could not be charged for the offense under 312 of causing miscarriage if the victim did not have a child at all. But the court said that she can be charged for attempting to commit miscarriage, attempt to commit the offense of causing miscarriage. However, if we compare it with this Indian case of Rupse Panku, this was a case where the defendant wanted to poison the victim, but actually did not use poison, right? Did not use poison. She thought that she was using poison, but it was not poison. So the question is then, can she be charged for the offense of attempting to kill the victim? And this was what the court held. It cannot be said in the present case that the prisoner did an act towards the commission of offense. The offense which she intended to commit was the administration of poison to her husband. The act she committed was administration of harmless substance. So this seems to be very different. However, this is an Indian case, and this is a really old Indian case, 1895. So in my view, the view should be that the situation in Malaysia should be the same as in England, where even if it was impossible to commit the offense, a person can still be charged and be found guilty of attempting to commit that offense. So that brings us to the end of inchoate offenses.